G'day folks. Tonight we venture into the wild world of Papua New Guinean politics, where the government's legal strategy seems about as well thought out as a croc in a Speedo. Prime Minister James Marape and his mates are currently locked in a constitutional standoff with the Supreme Court, and it's a real corker. The drama began when the court, in its infinite wisdom, ordered Parliament to reconvene for a no-confidence vote against Marape. Seems simple enough, right? Not for our mates in government, it ain't. They've decided to challenge the court's authority, crying foul and claiming the judiciary is stepping on their legislative toes. This whole schmozzle has plunged the country into a constitutional crisis, with the separation of powers hanging by a thread. It's a right mess, and frankly, it's got us scratching our heads. Are Marape and his cronies legal geniuses playing 4D chess, or are they just a bunch of drongos with a law degree and a prayer? Let's dive into the madness and find out. So what's the beef all about, you ask? Well, it all boils down to a little thing called the Constitution, the very document that underpins Papua New Guinea's democracy. In March 2025, the Supreme Court ruled that the Parliament had acted unconstitutionally by rejecting a no-confidence motion against Marape. The court, citing sections 111, 125, 142, and 145 of the Constitution, ordered Parliament to sort itself out and address the motion properly. They even invoked sections 18, 19 and 155, which basically give them the power to step in when the government's gone rogue. But here's where it gets juicy. Instead of accepting the court's ruling like good little parliamentarians, the Marape government decided to throw a spanner in the works. They cried foul, claiming the court had overstepped its bounds and violated the separation of powers. They pointed their fingers at sections 99, 115, 124, 134, and 11 of the Constitution, arguing that the court had no right to interfere in parliamentary business. It's a classic case of, he said, she said, except the stakes are much higher than who stole the Tim Tams. Now, you might think that facing a Supreme Court ruling would give even the most hardened politician pause, but not our mates in the Marape government. They decided to double down on their defiance, essentially telling the court to shove it where the sun don't shine. The Speaker of Parliament, no doubt urged on by Marape and his cronies, refused to convene Parliament for the no-confidence vote. They even had the gall to publicly criticize the court, accusing it of overreach and undermining democracy. Talk about biting the hand that feeds you. This blatant disregard for the rule of law sent shockwaves through Papua New Guinea. Legal experts and opposition politicians alike condemned the government's actions, calling it a dangerous precedent that threatened to unravel the country's democratic fabric. But Marape and his mates remained unmoved, seemingly content to play a game of chicken with the highest court in the land. It's a bold strategy, Cotton. Let's see if it pays off for them. Section 4, Deja vu. History repeats itself again and again. Here's the kicker, folks. This isn't the first time the Supreme Court has had to step in and remind the government of its constitutional duties. In fact, the court has ordered Parliament to reconvene on at least 5 previous occasions due to similar shenanigans. It seems like every few years, some bright spark in Parliament decides to test the boundaries of the Constitution, only to be slapped down by the judiciary. You'd think they'd learn their lesson, wouldn't you? But then again, we're talking about politicians here. Logic and reason ain't exactly their strong suits. This pattern of defiance and judicial intervention raises serious concerns about the state of Papua New Guinea's democracy. If the government can simply ignore the rulings of the highest court in the land, then what's the point of having a constitution in the first place? It's a question that should give every Papua New Guinean pause. Because when the rule of law is eroded, it's the everyday people who suffer the consequences. Section 5. Legal eagles are legal beagles, the government's flawed strategy. So what's the end game for Marape and his merry band of constitutional crusaders? Well, only time will tell, but one thing's for sure, their current legal strategy is about as effective as a screen door on a submarine. By challenging the authority of the Supreme Court, Marape is essentially sawing off the branch he's sitting on. He's undermining the very institution that is supposed to uphold the law and protect the rights of all Papua New Guineans. It's a move that has left even his most ardent supporters scratching their heads. Even a first-year law student could tell you that defying the Supreme Court is a recipe for disaster. It's like trying to fight a cassowary with a pool noodle. You're gonna lose, and it ain't gonna be pretty. The government's argument that the court is overstepping its bounds is about as convincing as a $3 bill. The Constitution is crystal clear on the separation of powers and the role of the judiciary. The court has a duty to intervene when the government acts unconstitutionally, and that's exactly what they're doing. Marape's attempts to paint himself as a victim of judicial activism are laughable. He's the one who's playing fast and loose with the Constitution, not the court. If he doesn't like the rules, he's free to try and change them through the proper channels, but until then he's bound by the same laws as everyone else.